next of kin and all that you need to know about next of kin in Nigeria. With us today is the doyen of law practice, as a matter of fact, the doyen of family law, the Honorable Justice Oguntade of the High Court of Lagos State, Probate and Family Division. And she will be assisting us greatly today to discuss the issue of next of kin, especially the extent of the next of kin powers and what a next of kin can do in Nigeria. So before we dive into the next of kin, we'd just like to show you briefly what we do at Meristem Securities Limited, and of course at Meristem Trustees Limited, the subsidiary of Meristem Securities. Please, Heidi, play the video. Thank you.
Good afternoon, host. Good afternoon, ladies and gentlemen.
Good afternoon, ma'am.
It is a privilege to be here with you, to be able to contribute to knowledge of law. My paper this afternoon is on the issue of the limits, really, of a next of kin. Most of the time when we all hear the term next of kin, we usually refer to the closest person to an individual. Most of the time, we always think it is that family member, that spouse, that child that is a next of kin. Also, some of us see a next of kin as that person that we need to be contacted in the event of an emergency. It is very important that we note now that the term next of kin can have different interpretations depending on the context and situation that comes up. A next of kin is someone that can be used on bank forms, on emergency forms, on employment forms. That does not mean the person stands to inherit an estate when you become deceased eventually. The whole essence of this paper this afternoon is to clear the air on how much a next of kin can do, and to interrogate and provide the necessary insight into the implications of a next of kin. So we will go first to the dictionary, and I have chosen the Black's Law Dictionary. The word next of kin in that edition refers to a person or persons most closely related to you by blood or affinity. A person's next of kin is his closest living relative. Someone whose name you offer on forms and questionnaires. I take this view more seriously with the decision of the Court of Appeal in a case, Joseph versus Fajemile. It was decided in 2012, LPELR 9849. The Court of Appeal in that decision of the court held, and I quote, "Let it be placed on record that the term next of kin can be used in three senses. First, it can be used to simply refer to the nearest blood relative. Two, it can be used to show the person who is to be notified in case of any eventualities of life, such as an accident, emergency, or even death. Again, it may be required to make medical decisions, such as providing information or consent for a person who is incapacitated. And just now it came to mind that it can also be used to refer to an heir. This is my next of kin. Having established the four different circumstances where you can use the term next of kin, it must be expressly stated that being designated a next of kin does not confer the right of inheritance. Let me repeat that again, because that is the crux of this paper. A next of kin does not mean you have the right to inherit property or an estate. There is no automatic claim to the estate of a deceased. It is instructive to note that in Nigeria, we determine inheritance mostly by customary law, by Islamic law, and by statutes. Statutes for the common man means those laws that are in those law books, laws made by the National Assembly and House of Assembly of States. Particularly, it is dependent on the kind of marriage contracted by the deceased during their lifetime. It also matters what the law of the land where the property itself is situate. So, in essence, three types of marriages are recognized in Nigeria. They are statutory marriages, those marriages contracted under the Marriage Act. Those are the church marriages, the registry of your local government marriages. We also have the customary law marriages. Those are the ones that we call traditional marriages. And we have Islamic law, the marriage conducted under Nikah. All these three are different manners in which you can dispose of your estate. And it also shows how you can dispose of your properties in a legal manner. For example, inheritance under these three forms of marriage is guided by the administration of estate law of each state of the Federation. Therefore, to inherit a property, merely being married is not enough. Merely being a married next of kin is not enough. Merely being named next of kin is definitely not enough. A person, an individual who stands to inherit under the estate of a deceased person has to be named in a will as a beneficiary. As this paper goes on, you will understand clearer. In another case, my authority to speak is backed by legislation. Per George Adesola Oguntade, JCA as it then was, in Obuzes versus Obuzes, 2001, 15 NWLR, part 736, at page 377, in explaining the rules governing succession to estate of intestate person married under the Marriage Act, poignantly explained this, that section 49 sub 5 of the Administration of Estates Law, cap 3 laws of Lagos State, that where any person who is subject to customary law, for example, contracts a marriage in accordance with the provisions of the Marriage Act, and such person dies intestate, that is without a will, leaving a widow or husband or any issue, any child of such marriage, any property of that person shall be distributed in accordance with the provisions of the Administration of Estate Law. This is notwithstanding any customary law to the contrary. Let us remember that the contention here in looking into the value of the term next of kin is particularly where there is no will. If a person is named in the will, automatically that is legal status for inheritance. Following from the quote of the case, it is obvious, manifestly clear, that a next of kin cannot seek to inherit the estate of a deceased intestate, especially when the marriage is under the Marriage Act. The administration of estate goes on to require that people apply under Section 49(1), which also lists the line of people entitled to a grant of letters of administration. Let me digress for about a minute. What I am trying to put out there is that a deceased person can leave a will. In the will, you name the beneficiaries. Your choice is sacrosanct. Nobody can tamper with it, except if the validity of the will is put in question. But situation and circumstances arise where a deceased person does not leave a will. The law allows his relatives to apply for a letter, for letters of administration. Now, Section 49(1) of the Administration of Estates Law lists in order of priority who has the right to apply for letters of administration. The long list of people entitled to be granted letters of administration, to wit, is in this order upon proof of same. 1, the surviving spouse of the deceased person, that is the husband or wife. 2, next in line, comes the children of the deceased person and their own children. Next, parents of the deceased person. Following that, brothers and sisters of full blood. Next to that, brothers and sisters of half blood. Then we have grandparents of the deceased, following which we have uncles and aunts of the deceased. Creditors and the Administrator General coming last in a situation where the preceding list failed. Furthermore, where the marriage contracted by the deceased is under native law and custom, succession and inheritance will be influenced by the personal law applicable to the deceased. Therefore, inheritance is guided by customary norms of where each of us come from in the land. What is important is that such customs must not be contrary to the doctrine of natural law, equity, and good conscience. such as where a custom seeks to exclude the husband or wife or children of the deceased from inheritance. Such customs are repugnant to the doctrine of natural law, equity, and good conscience. I'll give you an example. Under the Benin native law and customs, it is a tradition that the Igiobe, the word means house where the father lived, goes to the eldest surviving son of the family. In the case Idehe versus Idehe, 1991, 6 NWLR, part 198, at page 422, particularly paragraphs A to F, Honorable Justice Belgari, JSC as it then was, opined on the Benin customary law of inheritance as follows. And I quote, in Benin customary law, the Igiobe could not, under any circumstances, be given away as a gift. It must be left for the eldest male child. At his death, the testator is entitled, under Benin customary law, to devise all his property except the Igiobe. Therefore, Igiobe would, at the death of the deceased, no longer be his to give away. From the foregoing, it is clear that the term next of kin could be misleading and presumptuous at best. The fact that a person is designated as a next of kin on that emergency form, on that employment form, on that bank account form, does not confer the right of inheritance. In the absence of a will, necessary steps must be made to obtain a grant of letters of administration for the purpose of administering the estate of the deceased. Next of kin is not entitled to the estate of the deceased, except the will provides for them as named beneficiary. I'm sure right now you are all wondering, so what can I do as a next of kin? To what extent can I function? And what can I do with that power, so-called, of being a next of kin? It even goes to the question, as a next of kin, can you bring a court action on behalf of a deceased estate? Or can you even be sued in a representative capacity by the deceased estate? What I am leading to is the all-important question: can a next of kin bring an action to court or defend an action before a court? Can a court grant a next of kin the right of audience? The legal parlance for the right to bring an action is what we call in law the locus standi. That is, do you have a right of action? Do you have the locus as a next of kin to come before a court of competent jurisdiction? In a plethora of authorities, the locus standi, which is your right to bring a case to court, your right to bring an action in court, is an issue of jurisdiction. If you have no right to bring an action, and you do, to a court of competent jurisdiction, the jurisdiction of that court will be removed because of the fact that you had no power, no right to bring an action, and you did. What that means in clear common man terms is that the court will not be able to hear you at all and determine the action you brought. What for the action, any action, to be competently brought before a court of law with respect to an estate of a deceased intestate, such would have to be brought by juristic persons. I am sure you're wondering, juristic persons? Yes. Juristic persons, not the next of kin. Juristic persons are trustees, executors, and administrators of the estate of a deceased person, and no other person. In the case Union Bank versus Mkena, 2019, LPELR 47197, the court said, and I quote, "It is not in dispute that the plaintiff brought this action as the next of kin of the late Dr. Teruman Mkena. It goes without saying that such a standing, such a locus, such a status, listeners, as a next of kin cannot vest the plaintiff with the requisite capacity to sue. Without any doubt, the court went further. Where a party purports to bring an action in respect of the estate of a deceased person, for you to be heard by a court, for the court to be able to determine your case, you have to bring it through a trustee, an executor, or administrator of the estate. Now, flowing from the above, it is clear that a next of kin cannot bring an action in a representative capacity regarding the estate of a deceased person. In spite of what I have said. God forbid. A situation where the right to bring an action in respect of the rights of a deceased person is absolutely foreclosed on the basis of being a next of kin. The limitation on the position of a next of kin in bringing an action in respect of the deceased has a little ray of sunlight under fundamental human rights. I repeat, the limitation placed on a next of kin in instituting an action in respect of a deceased person is only limited to civil cases. There is an exception to this principle, and that is found under the Fundamental Rights Enforcement Procedure Rules. Herein, rights of a deceased person, if deprived at all during his or her lifetime, can be brought by a next of kin. Notably and of importance is the Constitution of the Federal Republic of Nigeria, paying particular attention to Section 46 of 1, which provides for any person to take steps or initiate proceedings where any of the rights provided under Chapter 4 of the 1999 Constitution as amended are in issue. Fundamental rights actions can be brought by anyone, including the next of kin, and even a busybody. It can be a passerby, just somebody that comes upon an infringement of a right. The requirement of locus standi, and I'm sure you all remember that that means a right to bring an action to court, is non-existent, especially when it comes to the right to life. In giving meaning to the provisions of the Constitution, Yagata Bayanchit Nimpa, Honorable Justice of the Court of Appeal, in the case of Dealey versus IGP and others, 2016, LPELR 4152, said any person includes next of kin of a person whose rights have been violated, includes busybodies, includes friends, unknown persons, relatives, anybody. Of interest and instructive is the preamble to the Fundamental Rights Enforcement Procedure Rules 2009. It allows in Section 3A that the Constitution, especially Chapter 4, as well as the African Charter, shall be expansively and purposely interpreted and applied with a view to advancing and realizing the rights and freedoms contained in them, thereby affording the protection intended by them. It is also on this note that the court encourages and welcomes public interest litigations in the human rights field, and no human rights case may be dismissed or struck out for want of locus standi. It can never be a reason for the court not assuming jurisdiction, because anybody can bring a case under the fundamental human rights procedure. Now, from the foregoing, it has been established that a next of kin is limited in its powers to act for an estate of a deceased or for a deceased. A next of kin lacks the virus to also inherit properties which have not been expressly assigned to him or her. I have no difficulty in stating that estate planning should be explored, especially where a deceased has not left a will. It is good to plan by preparing a will and appointing trustees and executors of the terms of the will. That way, some level of peace and understanding can be guaranteed during the sharing of the deceased estate, which may also prevent frivolous lawsuits that only clog the judicial system. In view of all I have said, what is the limit of being a next of kin? I must sound off this topic with the advice that the ownership right of a deceased person during his or her lifetime over his or her estate does not automatically become rights of a next of kin upon the demise of the deceased person. In essence, and without a doubt, a deceased next of kin is not a next to a deceased properties. Only someone who can be called upon in any case of eventuality or emergency. A next of kin will only be needed for the provision of some vital information and for making certain decisions on behalf of the one who named him or her, and not to inherit property by virtue of death. The relevance of a next of kin for the purpose of the administration of an estate an intestate estate is to bring together the relatives of the deceased and ensure that the necessary steps of obtaining probate are properly complied with. Probate is where a person dies without leaving a will, letters of administration. Where there's a valid will, the role of the next of kin is dispensable. Where there's no will, the role of the next of kin is dispensable, save and except letters of administration are applied for and granted. In consequence, therefore, it is advised that if a person seeks and intends to have his next of kin inherit his property upon his demise, he or she must ensure that he or she makes a valid will during his or her lifetime, naming the next of kin as a beneficiary of his estate, or at least naming trustees, executors, and administrators in his will. But as I said, and in the final analysis, it is agreeable to a large extent that a next of kin, without a doubt, is usually the closest person to a deceased. This position, though, in relation to succession and inheritance, is presumptuous. Their right of actions and recognition is non-existent. It is useful with respect to seeking redress by enforcement of the fundamental rights of their loved ones, particularly the sacrosanct right to life, can never be called into question, as explained under Section 41 sub 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and the Fundamental Rights Enforcement Procedural Rules. I will end this by saying, answering that question, is next of kin good enough? I'm sure most of you can now answer that question by saying it is important to explore adequate estate planning to set machinery of peace and harmony in place whilst you are alive, preparatory for the afterlife. Thank you for listening.
Thank you, my Lord Honorable Justice Oguntade. The skills are falling off my eyes. I think my head has grown bigger from this load of information. I mean, when we started, I already commented that my Lord is doyen of family law and probate practice, and we can see it right here. And for those of us who may not know, I think it's worth restating that my Lord Honorable Justice Oguntade is a serving judge in the Family and Probate Division of the High Court of Lagos State. And our Lordship is a product of the University of Warwick, Coventry, United Kingdom. And she was called to the Nigerian bar in 1990. I don't know where so many of us were in 1990. Our Lordship started her career on the Lagos Judiciary bench as a magistrate before her elevation to the higher bench as a judge. And we can see that wealth of experience and knowledge in her presentation. And for those of us who could not follow attentively due to one thing or the other, rest assured that we have this presentation on YouTube. You can go on our YouTube and you'll see the recorded version on YouTube. So before we permit my Lord to leave, we have few questions. Just few questions. But before I go to the questions, we have dropped some links on the chat box. Two links. One is a link to a survey form. So because one key important thing that my Lord and pardon was the fact that just designating someone as your next of kin is not enough for them to inherit. And so one of the things we've done is to put a link on the chat box, our survey link, to enable you fill the link, and then we'll receive it and we're able to advise you. We also have a simple will link for those of us who want to set up a will so that you can adequately provide for your beneficiaries. I can see a comment asking that we repaste the link. We'll do that. So let me quickly ask some of the questions that we have here, my Lord. So the first question, and I believe that you've already touched this, but it will be worth restating to our attendees. So the first question is, if I designate a next of kin as my beneficiary in the bank or my place of work without a will, will the said next of kin have the right of inheritance? So this person is saying that, oh, they have a next of kin as their beneficiary. They stated that in their place of work and in their bank, but they don't have a will, they don't have a trust. Will that next of kin have the right of inheritance? That's the question, my Lord.
Thank you. As I earlier stated, just designating a person as a next of kin on documentation in the bank, employment, does not guarantee their access to your estate after your passing. It is tidier, it is fair, it is without rancor. The best and peaceful manner is to name the next of kin in a will as a beneficiary. But if you do not leave a will, the law allows the next of kin to approach the High Court and apply for letters of administration. But be careful here. The law lists in order of importance which persons in priority can apply for letters of administration. The most important person, where the person is married and it can be proven, is the spouse of the deceased. Where the spouse of the deceased is deceased, or there's been a divorce or separation, the next in line are the children and grandchildren of the deceased. I already went down the line of in what the ability to file for letters of administration is first the spouse, then the children, before you even come to the parents, You come to the siblings, you come to other relatives. Lastly is the administration general. What I'm trying to say is that a next of kin, as earlier stated, has no powers except to bring an action under fundamental rights under the Constitution. I hope that answers the question.
As the court pleases, the chair answers the question. Thank you, my lord. So I have two more questions, and then we can let my honorable justice leave the webinar. So, so one question here. I mean, bearing in mind how you've explained to us here today, what are the options available to individuals who have only designated next of kin? And we've all listened to your brilliant presentation that just having your next of kin is not enough. So we have a question here saying, what are the options available to individuals who all they have is the designation as next of kin? Thank you, my lord.
Thank you. Now, I'm sure we all know that you might even not be a relative and be designated a next of kin. You can be a best friend and be made a next of kin. In that circumstance, can a best friend inherit a friend's estate? No. You can be an employee, a person's staff or employer, and designate you as a next of kin. You can be a neighbor. You can be just somebody that an individual trusts as having integrity and nominate you and name you as a next of kin. You have no legal standing. As earlier stated in this paper, I'm trying to find the exact part so that I do not take it out of the order provided for by law. Section 49(1) of the Administration of Estates Laws of Lagos State highlights and lists the order of applying for letters of administration. First priority is the surviving spouse, the husband or wife of the deceased person. Second in priority are the children of the deceased and their issues. Now, more common is spouse and children combining to apply for the grant of letters of administration. Third in line of succession as provided under Section 49 sub 1 is the parents of the deceased. They come after the children of the deceased and their issues. Fourth in line is the brothers and sisters of full blood, same father, same mother as the deceased. Next in line is the brothers and sisters of half blood. Those are your step brothers or your half brothers, not step brothers. Same father, different mother, same mother, different fathers. They are half blood. Next in line, grandparents of the deceased person. After that, we have the uncles and aunts of the deceased. We have creditors, and then the Administrator General as the last, where all the others fail. It is manifestly clear that even if you are able to inherit under the estate of an intestate deceased, you must be in this line of succession. And the only way that you can inherit outside this line is for this long list to be absent, or you are unable to reach them, or they are all dead. And the likelihood of that, I don't know what percentage we should allot that. So yes, for a next of kin to inherit, you must fall under the long list pursuant to Section 49, sub 1 of the Administration of Estates Laws of Lagos State. Thank you.
Thank you very much, my Lord Honorable Justice Oguntade. It's been a privilege having you on this webinar today, and I am sure that all of our teaming attendees have been able to learn one or two things, especially the fact that have an estate plan, write a will, set up a trust. It is not enough to have a next of kin. We are far behind schedule, but before we leave, I have the privilege to call on Damilola Hassan, the Managing Director of Merisem Trustees Limited, to give our closing remarks. Good afternoon, Damilola.
Good afternoon. Thank you very much. Thank you very much, Honorable Justice Oguntade. You have done justice to this topic, and you can see from the chats, from the questions, from the comments, a lot of people have been well educated. Thank you for speaking to us from your very depth of knowledge on this topic. We are grateful that you have taken out time to do this for us. And of course, because we are Oliver Twist, and because we love to bring knowledge to people, we believe that knowledge is light. When people hear from people who possess, the right information, it goes a long way and helps them, to really do the right thing. So we will call on you again and again. But thank you so very much, my Lord, for doing justice to this topic. I want to encourage our participants on this webinar this afternoon. Please send in your questions. Even when we close the webinar, you can still send in your questions. Our email address is in the chat box, trustees@merisemng.com. Trustees, TRUSTEES @merisemng.com. We have shared links. Perhaps you want to take a quick survey to even determine if you understand what estate planning is about, or what should you be considering, in terms of your estate plan. There's so much to consider. You have to look at your family. You have to look at the size of assets that you have, the type of assets, the jurisdiction, the location of this asset. So many things come to play when you are planning your estate. And so we encourage you to reach out to us, speak to us as professionals, and let's rub minds on this so that you can be well informed and you can take the decisions that are appropriate, to your circumstance. At Merisem Trustees, we are very much committed to sharing knowledge. We do this from time to time, but I can assure you this is the first webinar this year, but we will do a lot more. It is coming to you free. And so we encourage that when you get our emails, our text messages, asking that you join our webinar, you should share also with other people. Let's spread this light. Let people know what they need to know so that they can make better choices. I would leave us now with this final word. I love this Chinese proverb, and I always refer to it whenever I'm speaking. This Chinese proverb says that the best time to plant a bamboo tree was 20 years ago. But then the second best time, if you haven't done that 20 years ago, is to do it now. So what decisions are you taking after this webinar? What have you put aside for a long time that you haven't gotten around to? Please pick your pen and paper and, take action. Send that email, make that phone call, write that will. It can be as simple as that. Some of us may think, I don't have much assets, but do those assets mean anything to you at all? If they do, then please ensure that at least you put a will in place such that you can easily pass on these assets, to your loved ones. I'll hand over now to the host, Dolapo, so that you can wrap up properly with the vote of thanks to our audience, and then we can call it a day. Thank you so very much, everyone, for joining us.
Thank you, Damilola, for your wonderful closing remarks. Once again, thank you, Honorable Justice Omotola Oguntade. We thank you that you are able to be part of us in spite of your busy schedule. We also thank our attendees. I mean, we started 12:30. That is in the afternoon. And I know that it's a time that is busy for almost everyone. You still made it a time with us. We really, really appreciate you. And thank you to everyone in Meristem who also helped us to pull this off. Thank you very much, and hope to see you very soon. So now we'll be leaving you with our generations video. Please just watch the video clips. It's also going to give you a very good idea of what we do at Meristem by helping you to plan your wealth from generation to generation. Thank you. Have a wonderful day.
You've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you.
The only way to move is up, the way to go, the top you've come this far.
Your story doesn't have to end with you. As a matter of fact, it can continue into the next generation and the generation after that. After all, you've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem, let's grow wealth for you.